Guys, my name is Amaan Ahmad. I'm a legal intern at LEXIS and Company, and I'm pursuing 3 years law faculty of Law Delhi University. The topic of my today's video is the importance of notice clause in a contract. So, the notice clause assists the parties to bring certain matters to each other's consideration with which affects their contractual norms directly or even indirectly. This clause generally contains the issues or matters relating to or affecting the provisions in the contract for which it is necessary to inform the parties through serving a notice, and also the manner of serving such required notice. Then the parties need to give each other a notice for various purposes, such as notice of overdue payment, notice of initiating a dispute, then change of address, termination, or having a waiver in writing, or even a renewal. Also, a notice have to be given. So this will tell you why does a notice clause exist in a contract. So a notice clause is a contract primarily serves two purposes mainly. So it's permitted to determine if notice was properly and timely given, and secondly creates a framework of what is to contract for communicating among themselves. A proper notice clause is a contract which clearly indicates the procedure to be followed for a valid delivery of the notice and deemed delivery. Provision as to chances of dispute by dishonest party claiming non-receipt of notice are minimized here. So what are the different types of notices? So a notice in a contract can be of two types mainly: generic and specific. Generic notice sets a structure for giving notices, to whom the notice is to be given, by whom it is required to be given, by when should it be given, at what address should the notice be given, for all types of notices. Then there are specific notices. It refers to that are only given only for a particular purposes, such as termination notice. Some of the important points while drafting a notice clause in a contract should be that how to deliver the notice. The mode of delivering the notice should be given. For example, a courier, mail, fax, all should be given in the contract explicitly. Then what is will be the notice be considered, and when will the notice be considered as properly delivered, and what will happen if there is a disruption in delivery of the said notice, if the sender has posted it but the receiver has not got it, if the sender has posted it and or the receiver was not in his house, or is voluntarily not letting the notice to be delivered, what are the remedies in that cases, and how and whom should the notice be addressed to. Then what should be the format of the notice, what is the proper format given in the notice, procedure to be followed for initiation of change of address or name of the designation of the recipient of either party in such a situation. The party whose address other details are going to change can notify the other party by sending a proper notice according to the contract also. So how to draft a notice clause? First is the whom should the notice be addressed to. While addressing the notice to an individual, ensure his or name is correctly spelled and it is sent to the address as stated in the contract. Make sure to clearly state that the address on which the corresponder or notices are to be sent. If the notice is sent to the corporation or an organization who do not draft the notice clause, requiring the notice to be addressed to a recipient's personal name, because the person might leave the organization or a designation might change, as a notice might accidentally be ignored. Therefore, the best practice is to mention the recipient's designation or office, such as the company secretary, the CFO, or the CEO, etc. These should be mentioned. The notice clause precisely states the address at which the party is supposed to end the notice and designation of the address at the time it will be considered to has been served. So how is the notice to be given? First, for ensuring delivery of the notice, specify the mode of delivery, such as email, by post, speed post. Select the method that provides you evidence of the delivery of notice. You don't want to be in a situation where the other party denies the receipt of the notice. That will enable a dishonest or defaulting party to delay proceeding and prolong a default. So for instance, consider a notice which was sent through an email, however it was not delivered to the other party because it was not sent due to the system error or crash of the site of organization email server or wrong email ID which you didn't know about. So how do you mitigate the problem? It can be done. For example, to completely avoid situation, always opt for such method for giving notice where you get evidence of delivery. For example, in case of a registered post with acknowledgement, anything that is sent through a post will require the signature of the party receiving it. The acknowledgement of such receipt by the receiving party is sent back to the sender. Then format of the notice in some contract, the theme of the notice language, especially in cross-border contract, is to be looked in detail as and when by whom the notice to be signed as mentioned in the contract also. Then change in the details of the party, ensure that the notice clause include the procedure to amend the details of the parties. This will be necessary to invoke in the event of change in address, legal entity's name, or the designation of the officer to whom the notice is sent. When you need to change any details in the notice clause pursuant to the above given, no information of the changes must also be intimated in writing as per the terms of the notice clause. So the last thing, what are the consequences of wrong drafting of notice clause? So the most common dispute that arises with respect to notice clause is whether it was effectively delivered or not. In landmark judgment of Energy Holdings PLC versus Philip Hormel, decided by the UK Court of Appeal, the notice clause of an agreement stipulated that the notice should be personally delivered. Thereby, the appellant went personally to the respondent house and kept the notice on the front porch table. However, this notice was not deemed to be delivered because personally doesn't mean just to leave the notice at the premise of the person. It means the notice should be given in person, delivered in the hands of respondent. Consequently, the notice was sent to be not delivered as if it was not given as per the manner stated in the agreement. When a notice is in hand delivered, a signature of the recipient on copy of the notice is obtained, so it could be presented in evidence subsequently if required. Thank you. That is all I want to say upon the notice clause and what are the remedies in case of wrong notice clause being drafted. And please remember, this video does not violate any guidelines of our Council of India and does not solicit or promote any of the advertisement, and the sole purpose of this video is educational. Please subscribe to the channel if you haven't already to see more of this content in future, and I'll be coming up with the next video very soon. Thank you.